When a husband dies, what is the wife entitled to? Upon losing her husband, the determination of what the surviving wife will inherit is going to be based on a combination of state law, the husband's last will and testament, his revocable living trust, any irrevocable trusts, retirement account beneficiary designations, payable on death or transfer on death account designations, pre-nuptial agreements, post-nuptial agreements, and potentially other estate planning documents. However, barring exceptions, such as those pre- and post-nuptial documents we talked about, every state in America prevents a spouse from entirely disinheriting their spouse, no matter how long the couple has been estranged or how much the decedent wished to keep his wife from receiving an inheritance. In California, which is a community property state, the surviving spouse is going to be entitled to at least 1/2 of any property or wealth accumulated during the marriage, which is usually community property. Again, absent a prenuptial or postnuptial agreement that states otherwise. This is because each spouse owns 1/2 of all community property earned during the marriage. And this is true regardless of which spouse earned or acquired the community property. If you're a surviving spouse who's being told you're not going to receive your fair share of your deceased husband's estate, either through a will, trust, intestacy, or other document, then you need to consult a probate litigation attorney who can help you determine and enforce your rights, which may include contesting a will, trust, or other distribution in court. Have questions? Schedule a free consultation on our website, rmolawyers.com. Does the wife get everything when the husband dies? A wife certainly can receive everything when a husband dies, and it's very often the case that she does. A classic example is where the husband dies without a trust or last will and has no other surviving next of kin. Also, a husband can choose to ensure his wife receives his entire estate when he passes through proper estate planning. Imagine a husband wants to prevent a child from a previous marriage from claiming any inheritance. He can sign a will or execute a trust, leaving all of his assets to his wife. Typically, it's good practice to leave a sufficient amount to the disinherited child that deters them from challenging what you've done for the wife in court. This work, of course, should be done in consultation with an estate planning attorney who can help you with that drafting. If a husband passes away without a will or trust, his estate is likely going to be distributed according to the state intestacy laws. In the case of the man who has one child from an earlier marriage, in California, his surviving spouse will receive all their community property and at least half of the husband's separate property. Assuming the child is the husband's only offspring, that child will receive the other half of the husband's separate property. That is, the property he had before his marriage or property that he inherited during the marriage. These are complex factual and legal issues and should be handled only with the assistance of an experienced probate litigation attorney. What is the first thing to do when a spouse dies? Beyond taking care of funeral expenses, arrangements, and contacting loved ones, the first thing you should do when your spouse dies is to locate any estate planning documents. These might include their most recent will, any trust documents, records of payable-on-death accounts, beneficiary designations, insurance policies, annuities, etc. If there are no documents, then that's something for you to discuss with your lawyer. Next, you should contact your estate planning lawyer. And if you don't have one, you should locate one to help you administer your deceased spouse's estate. If you think there are going to be problems from children, heirs, business partners, or other third parties, then instead you should contact an estate litigation lawyer who can address your concerns and make sure you're protected. The sooner you retain a lawyer, the better you'll be able to understand your rights and obligations and know the next steps that you're going to take to ensure the estate is administered properly so you can receive your rightful inheritance. Have questions? At RMO, we protect people like you every day. Give us a call, shoot us an email, or schedule a free consultation on our website, rmolawyers.com. Thanks for watching.